Assalamualaikum warahmatullahi wabarakatuh. The Honorable Memrina Syahriani Syahrullah PhD. The Honorable Miss Nina Zahara Silviani SH.MH. My name is Delvin Shakira Mahar. I am a student of Batam International University, Faculty of Law, Class 4 IHPA with NPM 2051039. The purpose of making this video is to fulfill the final semester examination project for the private international law course. On this occasion, I will discuss the material of family law provision. What is family law provision? Watch this video until it's finished. According to Professor Mr. Dr. L.G. van Apeldoorn, family law is the regulation of legal relation that arise from family relationship. According to Professor Sudiman Kartohadiprodjo SH, family law is all the rules of law that determine the and method of establishing a relationship as well as a result. General understanding, legal relationship arising from both family life due to marriage and descendants. Then, what are the elements in the family law provision? 1. Mixed marriage. In mixed marriage, each party must comply with the national law or principle of nationality, and 4 formal requirements in the implementation of mixed marriage. It must be subject to the law when the marriage was performed, or lex loci celebrationis. But of the condition must be met in order for a marriage to be valid. Referring to the definition of mixed marriage, according to Law Number 16 years 2019, namely marriage between two people in Indonesia is subject to different laws due to difference in citizenship, and one of the parties is an Indonesian citizen. According to private international law theory, an international mixed marriage must meet 2 conditions, namely material requirements based on the national law of the prospective bride and groom, or the legal basis is Article 16AB, and formal requirement based on the law where the marriage take place, or lex loci celebrationis, or legal basis Article 18AB. 2. Marriage annulment. The annulment of the marriage refers to the marriage law, which is regulated in Article 22 to Article 28 of Law Number 1 of 1974 concerning marriage, where the marriage is carried out by fulfilling the following elements. A. Marriage are carried out under terms that violate the law, or Article 27 of Law Number 1 of 1974. B. One of the parties falsifies his identity, or Article 27 of Law Number 1 of 1974. False identity, for example, about status, age, or religion. C. Husband or wife who still has marital ties and carries out marriage without the permission and knowledge of other parties, or Article 24 of Law Number 1 of 1974. D. Marriage that is not in accordance with the condition of marriage, or Article 22 of Law Number 1 of 1974. Marriage is basically a legal event like an injunction which can be cancelled. Efforts to cancel a marriage or carried out based on the law of the place that stipulates and enforce the material requirement of the marriage in question. This also applies to mixed marriage or marriage held abroad, must refer to the condition for the validity of the marriage, which can be requested by the parties stipulated in the marriage law. 3. Marital will. Based on the provision number 5 of 1960 of the Basic Agrarian Law, Foreigners might not have ownership right, building utilization right. Indonesian citizens who change citizenship to become foreigners must relinquish their right to land, namely through the transfer of buying and selling grains or wheels no later than 1 year after obtaining this right, or rexitai. Property in marriage, Article 35 of Law Number 1 of 1974, which in full reads as follows: 1. Property acquired during marriage becomes joint property. 2. The inheritance of each as a gift or inheritance is under the control of each alone as the parties do not specify otherwise. With regard to land right, in Law Number 5 of 1960 concerning basic regulation on agrarian principle, it is stated that only Indonesian citizens can have property right on land. So, for mixed marriage, which do not determine otherwise the asset in the marriage, or with a prenuptial agreement, cannot own land with property right due to the mixing or marital property which foreigns. 4. Marriage agreement. The marriage agreement is regulated in Article 119 of the Civil Code. Marriage agreements are important in mixed marriage because with the marriage agreement, the husband or wife who is an Indonesian citizen still owns immovable objects such as land or houses. In principle, a marriage agreement is a form of agreement. Marriage agreement is an agreement that is held or made by prospective husband and wife before the marriage takes place with aim to regulate the right and obligation of husband and wife on their respective assets brought into the marriage. Marriage that is legally carried out by husband and wife will bring consequences in the legal field, one of which is in the field of law. Husband and wife who are bound in a legal marriage will have property bought before and during marriage. Preventive action to anticipate the occurrence of conflict before marriage is to make a marriage agreement. The parties who promise are free to make agreement as long as they do not violate decency, public order, and the law. Usually contains arrangements for the settlements of problems that will approximately arise during the marriage period, which include 1. Separation of asset. 2. Separation of husband and wife incomes asset. 3. Separation of asset for debt. 4. Separation of property for children and others. Regarding whether or not the context of the marriage agreement are changed during the marriage, it has been determined in Article 149 of the Civil Code, which states that after the marriage takes place, the marriage agreement in any way cannot be changed, but if you still want change, you have to go through an agreement between husband and wife. 5. Legal relationship of parents and children. The legal relationship between parents and children is governed by the national law of one of the mothers or fathers, or the national law of the other parents in the event that one parent dies or is uncount, or based on the law of the child permanent resident or lex domicile. The provision of the child in question are late marriage children, and in the event that occurs outside of marriage which is recognized by Indonesian law, the child only has a civil relationship with his mother and his mother's family. Indonesian law provides legal status regarding citizenship, status that every child is an Indonesian citizen when referring to Article 4 of the citizenship law. And every parent is obligated to take care of their child as well as possible, This also applies to guardianship relationship where the applicable guardianship is the law in which the child belongs or the child nationality. Guardianship of minors, which applies is the law of both parents. 6. Adoption of children between countries. There are two types of child adoption, namely adoption which intends to imitate the natural relationship of parents and children, or plena adoption, and adoption which intends to maintain and meet the needs of the child, only adoption minus plena. There are at least two conventions from 1. The Hague Convention, namely the Convention of 15 number 1965 on jurisdiction, applicable law and recognition of decreased relation or the adoption, or the 1965 Convention. 2. The Convention of 29 my 1993 on protection of children and cooperation in respect of inter-country adoption, or the 1993 Convention. These conventions are timed by countries to regulate the adoption of children between nations, or also called the adoption of children with foreign elements. The principle applied in child protection is the best interest of the child in the implementation of child adoption if the prospective adopt child and prospective adopt parents have the same citizenship. Namely, Indonesian citizenship, the adoption is carried out on Indonesian law. Meanwhile, if the citizenship between the two parties are different, where the citizenship of the prospective adoptive parents are foreign national, while the prospective adopted children are Indonesian citizens, the procedure and condition for adopting are determined by Indonesian law. 7. Divorce. Regarding divorce, there are three opinions, namely: 1. If one of the bride and groom is a native citizen, the divorce pronounced by the judge of the country and the place of residence of the non-citizen of the bride and groom shall be recognized. 2. If both are original citizens, the then divorce decision obtained outside on a basis that is now ground in the national law of that citizen is difficult to recognize. 3. If both are original citizens, but one of them is the party, then divorce is recognized in the foreign country if that citizenship is effective. Then the condition that needs to be realized in the regulation of private international law is that the legal determination of divorce from transnational marriage is based on citizenship law. And last, law of inheritance. Inheritance in private international law can occur by itself, without the legal action of the testator, namely through a legal action that the testator did while he was still alive by making a testament or will. Article 830 of the Civil Code also states the same thing, that inheritance only occurs because of death. Every human being has the right to inherit from each other as per the element of inheritance, namely: 1. There is an heir. 2. There are heirs. 3. The existence of inheritance. Regarding heirs, who are said to be heirs or people who are entitled to receive the inheritance of the heir, either because of a family relationship or because of a will. Well, that's all my brief explanation of the family law provision. Now, I will give an example case regarding the family law provision.
Named Gavin Edward Leader, bin Ron Edward Leader, who was a foreign national and lived in Perth, Australia. Then he met a woman named Yayu Rujani binti Murijan, who was an Indonesian citizen. After being acquainted for a long time, They fell in love with each other. And in the end, they decided to marry in Indonesia according to Islam before the Marriage Register or PPN of the Bongorejo District Religious Affairs Office. Based on the marriage certificate question number 0075/016/4/2013. 2013 February 12. After getting married, they decided to stay and settle in Indonesia. Not long after the wedding, there was a baby named Raden Bailey Leader who added to the harmony of their household. During their marriage, Gavin and Yayu worked together to support their small family. It can be said that they are a well-off family. They have a joint savings of 350 million rupiah and have several vehicles, namely 1 car and 2 motorized vehicles. In Gavin and Yayu marriage, they made a marriage agreement regarding the separation of assets. As stated in the marriage agreement that number 02, which was made before Michelle Subagio SHMKN, notary in Banyuwangi. Date 2017 April 5, which was made after the marriage contract was held. However, the marriage agreement has not been ratified in the register books. And on 2017 April 10, Gavin and Yayu through their proxies won the register a marriage agreement that has not been ratified by the KUA of Bongorejo District. Therefore, Gavin and Yayu submitted to the Banyuwangi Religious Court to ratify the marriage agreement deed and to provide legal certainty to both parties regarding the separation of the asset.
The judge hereby decides: 1. Granting the application of applicant and respondent. 2. Declaring the validity of the marriage agreement number 02, date 2017 April 5, made by and before Michelle Subagio SHMKN-MH, notary in Banyuwangi. 3. Ordered the applicant and respondent to register the marriage agreement with the head of the Office of Religious Affairs, Bongorejo District, Banyuwangi Regency, to be recorded in the 2013 marriage register. 4. Charge applicants and respondent to pay court fees in the amount 381,000 rupiah.
But the case in the form of animation that I showed earlier is an example that is very closely related to some of the elements I have mentioned earlier, because it contains element of mixed marriage, separation of marital property in mixed marriage, and this is in line with the marital I discussing, namely family law provision. Well, maybe this is all I can convey. Sorry if there are many mistakes. Hopefully it can be useful for all of you. Thank you for watching my video. Thank you so much. Bye bye guys.